DJ Howard, I'm assuming you're Daryl Howard. I'm going to ask you to unmute your device, turn your video on. Mr. Malaro, you as well. Hi, Mr. Howard.
I'm here, buddy. I'm here.
All right, awesome. All right, this is in the matter of the people of the state of Michigan versus Daryl Levon Howard Jr., file number 19-19661FH at Salvatore Malaro, appearing on behalf of Mr. Howard. I have Sarah Brenner appearing on behalf of the Attorney General.
Your Honor, I would like to represent myself.
But don't interrupt me, so hold on a minute. I have Sarah Brenner appearing on behalf of the people. This is the date and time set for a pretrial in this matter. This is actually a final pretrial before trial. We are scheduled for trial on March 9th, next week at 10:30 a.m. So, Mr. Howard, I will now, what did you say?
I said I would like to represent myself. I'm here in propria persona. UCC 1-308, reserve all my rights.
Okay, so you wish to...
Just keep watching. Both Attorney Brenner and Malaro are fantastic. They both leaned in to make sure that they caught it all. And it is fantastic. Also, the judge is great. She's having none of it.
You no longer have an attorney represent you?
I'm a man in flesh. I'm representing the subject. I'm here for the subject matter at hand.
That doesn't make sense.
I'm representing myself. I'm here. I'm here under God.
So you wish
my
to
man living.
Say it again?
A man living in flesh. Daryl Howard. For the record.
Well, you're not dead because you're talking to me. So, but I don't know what you're saying other than that. But so you no longer wish to have an attorney represent you?
Here in propria persona, yes, Your Honor.
Okay. Do you wish to have an attorney as a standby counsel to answer questions if you have any?
No, Your Honor. I like to represent myself.
Okay, Mr. Malaro, Mr. Howard no longer wishes
Here
to be
in propria persona.
Well, Judge, I would suggest that Mr. Howard hear out Ms. Brenner before he makes a final decision about having an attorney.
All right, so Mr. Howard, evidently something arose and Ms. Brenner has something she'd like to place on the record. So what I would suggest is that you hear what Ms. Brenner says and then perhaps you go into a breakout room with Mr. Malaro for him to explain the ramifications of it to you before I decide on your request to represent yourself, okay?
Yeah, I would like to. I reserve all my rights. UCC 1-308.
UCC does not apply to criminal matters, so.
I mean, it's obvious, but I've been waiting for a judge just to hit him with that particular point. This judge has been fantastic so far. She maintains her calm, but she just smacks it down dispassionately and appropriately. It's fun to watch.
Okay, so Mr. Howard, Ms. Brenner, do you have a statement you'd like to place on the record?
Yes, Your Honor. Mr. Malaro and I have been discussing this matter over the last couple of weeks and discussing potential resolutions. After discussing this with Mr. Malaro, even though when the defendant was originally arrested, he owed just over $5,000 and arrearages have grown to over $8,000 at this point, I have agreed with Mr. Malaro to offer the following. If the defendant wishes to enter a guilty plea today, then I would be asking the court to set a sentencing date out 60 days. If the defendant makes his payments during that time period, which is only $150 a month that he's ordered to pay at this point, I would be requesting no upfront jail at the time of sentence. However, if he refuses that offer and we proceed to trial next week, when I convict him, I will be asking for immediate remand and I will be seeking incarceration because of the level of increase in his arrearages. I feel that this is a very lenient and generous offer that Mr. Malaro has convinced me to convey today.
Well, for the record, at trial, there's conviction. I always remand the custody of
I love that part right there. She's saying she's obviously trying to get the defendant to take the situation seriously because she's making a nice offer, and she's saying, I'm going to ask for a remand. I'm going to ask for you to be put in jail, effectively. And the judge comes back with, for the record, I always do that, which is a thing of beauty. And then Attorney Malaro is sitting there just thinking, what a knucklehead. And also knowing, yep, they're not lying. I know both of them. I also forgot to do this in the beginning. I want to thank Craig Hastings for sending me this clip. It's really a fun one.
The Sheriff's Department. So if I ever have guilty convictions at trial, I take people into custody. So, Mr. Howard, so I'm going to go through that again with you. So the prosecutor and Mr. Malaro worked out a plea agreement that if you were to plead guilty, we would set sentencing out 60 days. And if in that 60-day period, you made the $150 per month payment towards your child support, they would agree that you would receive no jail up front at the time of sentencing. So at the time of sentencing, you would receive probation, but no upfront jail. So do you understand that's the plea agreement that has been reached?
Your Honor, I challenge the jurisdiction of this court.
Well, you have to file a motion that you're set for trial next week. So
I've sent in 3 affidavits, ma'am.
Affidavits for what?
For this particular matter, ma'am.
I've received.
Come on, Judge. It's an affidavit of truth. No, this is too rich. This is too rich. He's so they've had multiple pretrials. They're set for trial in a week, and he's raising jurisdiction right now. Of course, he's not doing any of it right. The judge takes it back to him in excruciating detail here. It's beautiful to see.
Received no notice of any motions, Your Honor.
No, I've not received anything, nor have you served the prosecutor. Mr. Howard, when I had to hire an attorney to represent, when I had a civil case, I hired an attorney because there's a great philosophy that only a fool represents himself. You have the right to represent yourself. Do you have a law degree?
No, Your Honor, but if somebody,
do you have a college
education?
Do you have a college education? Okay.
I had giggled. No.
You have what?
No, go ahead, Your Honor.
Okay. So, Mr. Howard, you feel free to represent yourself. Doesn't matter to me. But I'm just saying you've been offered an opportunity for counsel who is intelligent and well-trained and well-experienced in the law. You may not like what he says, but Mr. Malaro always tells the truth. So, you do have the right to represent yourself. We received a letter. Okay, you sent a letter to the court. And you received a letter back stating that the court is in receipt of your letter mailed February 7th of 2022. Your letter is considered ex parte communication with Judge Anzalone, which is prohibited, Judge Anzalone, that's me, is prohibited from reading by Canon 3 of the Michigan Judicial Conduct Code. Additionally, you are represented by counsel and any motions must be filed by your attorney, and your letter was returned to you. So the court cannot read letters from parties because that is ex parte communication. So that letter was returned to you.
That is just a classic illustration. Usually they don't take the time to discuss it in that level of detail because they don't have the time. But right here, this is the case she's got up. So this guy does put together whatever, some silly thing he got off the SoftSit website. I'm guessing it's an affidavit of truth saying, you know, he's conqueror of the world and there's no claim against him or some such thing. But just in the simplest terms, they don't understand the law. You can't just write a letter to the judge. It's an ex parte communication. Any communication you have with the judge, the opposing party, in this case, the people, represented by Sarah Brenner, needs to have a copy of that communication. And if you want to discuss it further, you need to set it for hearing so that all of you are in the same place at the same time. So she just gets this crazy letter, which, by the way, is not going anywhere. What he wants is a motion to dismiss, although he doesn't have a basis. But if you want a motion to dismiss her, you need to file a motion, get a date set, have everybody there, and argue it. He has no concept of any of this stuff. But here we go.
If you file a motion, you must serve the prosecutor as well as the court. And so we don't have any motions. We just have a letter that you wrote. So you are scheduled for jury trial next week on March 9th at 10:30 in the morning. Are you prepared to go to trial?
I'll speak with Mr. Malaro after this, Your Honor.
I'm
You want to
sorry.
speak to Mr. He wants to speak to Mr. Malaro? Is that what you said, Mr.
Yeah.
Howard? You want to talk to Mr. Malaro? All right,
Yeah.
I'm going to assign Mr. Malaro and
The
Mr.
only intelligent
Howard
thing he
to a
said.
breakout room. Go ahead and join that breakout room.
Thank you, Judge.
All
Well,
right,
let's see if Mr. Malaro can talk
let's
some
see.
sense into him.
Israel Thompson's been here. Mr. Malaro, are you ready for me to bring Mr. Howard back?
Yes, Your Honor.
That was pretty quick, Sam.
All right, Mr. Howard, you would ask for a breakout room with Mr. Malaro. Mr. Malaro and Mr. Howard, how do you wish to proceed today?
Your Honor, after explaining the offer to Mr. Howard, I believe he understands it. He's indicated to me he is not going to plead guilty to a felony of any kind, and he desires to represent himself in this matter.
All right, so Mr. Howard, you wish me to remove Mr. Malaro as counsel for you, and you wish him to be a standby counsel in case you have any questions?
No, Your Honor, thank you.
Okay, so do you understand how to prepare jury questions?
I'm not,
Yes,
not
no.
sure I understand all the way, but I'm gonna get it done. Your Honor, so what is
No, I'm
the,
talking now, Mr. Howard. So do you understand how to prepare jury questions? And submit to the court?
I'm here appropriate of sounding, and I'll do it. I'll do what I have to do because under at least the laws of the land
That's
are
not what
made.
I asked. So are you going to prepare any requested jury questions?
Am I going to prepare? Yes, sorry, excuse me.
Okay, are you going to prepare any suggested voir dire questions?
Any what now?
Voir dire questions?
Oh, I'm sorry, I didn't hear you. Yes. I mean,
When you get a chance, rewatch it and just look at the smile on Attorney Brenner's face when he said when he asked that question.
Okay, you know, those were already those were due yesterday. So, I did not have voir dire questions. So, Mr.
Okay.
Howard, I received the voir dire questions from the people, but not from you. So, Mr. Malaro, is it possible to forward to Mr. Howard the voir dire questions and propose
I'm confident Mr. Howard has no idea what she is talking about.
jury instructions that you received from Ms. Brenner?
Yeah, I can send them out to him.
Okay.
I'll have our
So-
investigator deliver it to his house today.
Thank you. All right, so Mr. Howard, we will,
Whatever good that'll
Mr. Malaro will make sure that you receive the voir dire questions and proposed jury instructions that were filed by the people. The people also filed a motion in limine, and we've already held a hearing on that. Is that correct, Ms. Brenner?
Yes, Your Honor, and that was granted.
Yep, it was. So, Mr. Howard, you're set for trial on March 9th. Are you prepared to go to trial?
if I could get an extension, that'd be great. But if I have to go March 9th, then that would be the time I would need to go.
All right, because you are self-represented now, I will grant an extension. It's only set for 1 day. So Ms. Adams, could you bring the red book, please?
Sure. Your
Your
Honor,
Honor,
the only week I would not be available is the week of St. Patrick's Day. Other than that, I'm available.
Okay.
Your Honor, what is the subject matter jurisdiction of this court? I challenge the subject jurisdiction of this court.
Well, you have to file a written motion, Mr. Howard.
Yeah.
Okay.
All right.
For the record. Okay.
Yes, you've established on the record that you have no idea what the procedure is. But if that makes you happy,
All
okay.
right, so,
Who's the injured party in this matter, Your Honor?
Mr. Howard, what?
The injured party in this matter, Your Honor?
The what?
Who's the injured party in this matter?
The injured party, the victim in this matter?
Yes.
Okay, that would be the person probably that you're supposed to pay child support to.
I love it. It's a favorite soft sit trope. Who's the injured party? It's not necessary, so it's all dopey. But in this particular case, it's very clear. There's a very direct line. And he hasn't paid some child support, and there's an assault, apparently. I don't know, even get the complete unnecessary charges, but he actually tries this routine in something where you can answer the question without thinking. And the judge just enjoys saying, well, I mean, if you're asking this, I don't really need to answer, but here's a good answer for you nonetheless. Oh, it's too good.
All right, so I'm looking, how about, April 28th at 9 a.m.? Are you available that day, Ms. Brenner?
Yes, Your Honor.
So I'm going to set this for trial on April 28th of 2022 at 9 a.m. And Mr. Howard, that is in person, scheduled for one day. I am going to set a motion deadline for April 13. Wait, yeah, you're good. No, yeah, you're good. Okay. Are you available April 13th, Ms. Brenner?
Yes, Your Honor.
All right, so this is a motion deadline. So Mr. Howard, all motions must be filed and heard by April 22nd, which means you have to file it in accordance with court rules, with notice to the prosecutor's office, as well as the court. I'm going to require, Mr. Howard, that your jury instructions are also due by April 13th of 2022, as well as any voir dire questions. So
Right there is a good example. I say it all the time, but here's yet another example. It's very simple. He does not understand any of it. It's not helping him. But she's sitting there spoon-feeding all this to him and explaining what needs to be done. It's not out of line. That's what you have to do with pro ses. But while the stated rules, they get treated the same as attorneys, they don't. If I'm sitting there defending him, or Salvatore Motaro, she's saying, there's a motion deadline for this date. I presume you know everything that entails, and good luck.
Mr. Howard, this court does voir dire, but I do accept suggestions for questions to be asked and understand they must be in accordance with court rules. And if they are not submitted by that day, then you will not have the right to add any. Do you understand that?
I have
Yes?
it all written down. Yes. I mean, I don't want to accept the agreement, but okay.
All right, so I'm going to mail out the scheduling order, Mr. Howard. Okay, so we will make sure the scheduling order is mailed to you at that address. All right, so I have motion deadline and motion and limine deadline filed and heard by April 13th of 2022. And all suggested or proposed jury instructions in the appropriate format must be filed along with voir dire questions by April 13th of 2022. Mr. Howard, I believe you can access jury instructions online. You'll have to find them for the state of Michigan. And we're set for trial on April 28th of 2022 at 9 a.m. And understand, everybody needs to understand, I do take people in custody if there's a conviction. All right, so heading sentencing. So, Mr. Howard, we will see you back for any motions. If you file, now understand, if you file a motion, you have to prepare a notice of hearing and a proof of service, and it must be served on Ms. Brenner as well as the court. Do you understand that?
Yes.
All right, and you, once again, I'm going to ask, you do not wish to have standby counsel for trial?